Thank you so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the wonderful Ryan Suit, a Virginia construction lien law expert. Today's webinar topic is Lien and Bond Claim Masterclass, everything they don't tell you but should. So without further ado, I'd like to introduce the fabulous Ryan Suit.
All right, good afternoon, everyone. Thank you for being here today. My name is Ryan Suit. I'm an attorney at Pender & Coward in Virginia Beach, Virginia, and today we will be discussing liens and bonds in Virginia. So if you have any questions, go ahead and use the GoToWebinar chat box on the right. We'll address any questions at the end of today's webinar. Please don't include any names or company names, any identifying information in your questions. Try and keep things general. Otherwise, we probably will not be able to address them today. So jumping right into it, we'll first discuss the keys to mechanics liens in Virginia, what they are, how they work, and importantly, when do you get paid by them. Then we'll have a broad overview of bonds and bond claims in Virginia. I'll have a few general tips and words to the wise at the end before I'll turn things back over to Jessie and she can discuss some of SunRay's resources. So the keys to mechanics liens in Virginia. First and foremost, who can file a mechanics lien? All persons who perform labor or furnish materials worth $150 or more, including contractors, material men, architects, what have you, are able to utilize the tool that is mechanics lien. It might seem like a low amount, but that allows it to be used frequently on construction projects. It's for any person providing labor or furnishing material to condo units or limited common elements, and that is on there importantly because if a contractor does work on multiple condominium units or common elements that are used by multiple units, one mechanics lien is sufficient to encumber multiple units. Liens can also be filed by anyone providing labor materials for site development, such as preparing a site to be built out, building infrastructure, that types of thing. As I said, general contractors, subs, anyone who's in the contract tier can file a mechanics lien. In order to perfect a mechanics lien, you have to file a memorandum of lien. There's very specific information that's required for these liens, and you have to follow all of the rules to a T. Virginia is very strict when it comes to mechanics liens, and so you want to be sure that you are providing all the information that's needed. One important piece of information that the statutes require is that you have to actually mail a copy of the lien to whoever you're filing it against, either the GC or the owner, and then use a copy of the proof of mailing with the recording when you record the lien. So you have to mail it first, then record the lien on the property. Liens can be on improvements or on land. And if you have additional questions, you can see a few of my prior webinars that I've done with SunRay where I go into mechanics liens a little further. But before we get to bonds, the most important part of mechanics liens, in my opinion, is knowing the timeline. If you want to file a lien, you have 90 days from the last day of the month in which work was last completed. So if today is the last day that you perform work on a project, you would have 90 days from May 31st to file a lien. Also importantly, in Virginia, is the 150-day look-back rule. So if you were to file that lien 90 days from May 31st, it would only be valid for work performed or materials provided 150 days prior to today. So that's about 5 months. So if you did work 6 months ago, that can't be included in your lien. And that's important because if your lien does include work that can't be compensated by the lien, then the entire lien may be invalidated. So you have to be really, really careful with what's included in your lien and when you file it. Once the lien is filed, you have to enforce it within 6 months or 60 days after completion of the project. whichever occurs last. Typically, it is that 6-month period. But for further details, you can take a look at Virginia Code Section 43-17. So now we're going to jump into bonds and bond claims in Virginia. I'm going to provide a pretty broad overview here, starting with what is a bond. And a bond is a surety bond that provides security on a project as to when it will be completed, and that everyone who works on it will get paid. There are 3 parties to a surety bond issued on construction projects. The first is the principal, which is the entity that's responsible for actually doing the work on a project. The second party on a bond is the obligee. The obligee is the party who actually requires the bond, and this is most typically the owner or developer of a construction project. The third party is the surety. That's the bonding company that actually guarantees that the principal's obligation will be performed. And if there is a default on the project, then the surety steps in and fulfills the principal's obligation. So most typically in Virginia, bonds are used on public projects. They are not actually required on private projects, but they can always be used on private projects too. Typically, when I'm addressing the last bullet here, when do you get paid? You get paid hopefully before this bond even becomes an issue. A bond is more of an insurance that you will get paid in case of default. So ideally, you get paid in accordance with the contract. If you don't, then you would file a claim on the bond and you would get paid after filing that claim. Unfortunately, this sometimes requires litigation to get to the bond funds, and we'll talk about that a little bit later. There are a number of types of bonds. One of the most common is a payment bond. This is used to guarantee that all the parties that work on a project get paid. A payment bond is essentially the surety promising to pay a subcontractor or supplier if the general contractor defaults and does not pay. General contractors can also request that subs provide payment bonds. This is good for general contractors because it requires the sub to have some protection below them so that any lower tier subcontractors would have to go to the subs bond before they could reach up to the general contractor's bond. The second type of bond is a performance bond. This is essentially a way to guarantee that a contractor will finish a project, and it protects the owner from any costs to complete construction if a general contractor defaults. So if the general contractor defaults and fails to actually build a project, then a performance bond requires the surety to either arrange for completion of a project by choosing a contractor or somehow or in other ways funding the completion of the project. So it's ensuring the performance of the contract. A bid bond is a bond that's provided with a bid on a project, and it guarantees that a contractor will actually enter into a contract at the offered price, and will provide any required payment or performance bonds. A mechanics lien release bond is a bond that's posted more or less in exchange for a mechanics lien. So it's a way to maintain the protection of a mechanics lien, but to allow for that to be released from the property records of the land records of a property. This is commonly referred to as bonding off a mechanics lien and is done pursuant to Virginia Codes 43-70 and -71. There are a few other bonds that are a little less common when dealing with municipalities or for stormwater management, sometimes with roads, but those first 4 are the most common that we see in our practice. Now, before you file suit on a bond, there's some things you need to keep in mind. For payment bonds, it might seem simple, but you need to get a copy of it. Typically, a subcontractor or supplier won't have a copy of the bond, and the general contractor may not want to provide it to you. On federal projects, the bond can be requested pursuant to 40 U.S.C. Section 3133, so that you actually can get a copy of the bond. But there's no statute like that in Virginia, and so your best bet, if you're working on a public project, is to issue a FOIA request to get a copy of the bond. If it's a private project, it can get a little more complicated. Once you do get a copy of the bond, you want to review the terms. There's a lot of bond forms out there. They all might be a little different, so you need to know what obligations are required of you and required by the bond. Once you have all that, you file a proof of claim. This can sometimes have some very quick timelines, such as the mechanics lien timeline. You might have to file a claim within 90 days of performing the work. And you need to be careful that everything's correct, because once you file that proof of claim, any information you provide may be used against you as well. For performance bonds, it's usually a little easier to get a copy. Typically, the owner has that already, but you need to make sure that any notice requirements are met, as well as to ensure all the terms are followed. One common issue is that if an owner terminates a contract with a general contractor for some type of breach or default, if the terms on how to terminate a GC are not followed, then the owner could lose their performance bond claim. So you don't want to fall into any traps. Just make sure you know what the bond says. So we're going to get into a couple statutes here. So for federal projects, the Federal Miller Act is what would generally apply. This is a statute passed way back in 1935, and it requires that a general contractor that wins a job worth more than $100,000 must get payment and performance bonds. So it's just an extra level of protection that's required on federal projects. To be a proper claimant on the bond under the Federal Miller Act, you must provide construction, alteration, or repair on the project. So there are court cases out there. One big one was for a FEMA contract for the removal of debris. The contractor didn't get paid, tried to file a bond claim, but the court ruled that removing debris is not construction, alteration, or repair, and said that they did not have a proper bond claim. In addition, you need to be at least a second-tier sub under the Federal Miller Act. If you're beyond that in the contractor chain, you're not going to be able to touch those bond funds. There are a couple different requirements. One is for notice. If you're not paid, you must provide notice within 90 days from the last day you did work before filing a claim. And then you need to file suit within a year of when you performed your work, but not within the first 90 days. So any claim under the Federal Miller Act has to be at least 90 days old, if you will. So jumping into Virginia's Little Miller Act, this is essentially a state level statute that's very similar to the Federal Miller Act and has more or less the same purpose. It was enacted because contractors can't file mechanics liens against state projects. So this is it really is for public projects in Virginia. The thresholds are a little higher. So for payment and performance bonds are required for public transportation projects that are worth at least $350,000. And then for just general public projects, not for transportation, that are $500,000 or more. The claimants, to be a proper claimant, it's about the same as the federal requirements, but there might be some leeway given to second-tier suppliers. That's where the case law gets a little gray. The Virginia Supreme Court has heard some cases on it. They've gone some different ways, and they've analyzed a few factors. But generally, for a rule of thumb, it's about the same as the federal requirements to be a claimant. So for other requirements, the notice is about the same as the Federal Miller Act and the same filing schedule, where you can't file suit until the amounts owed to you have been owed for at least 90 days, and then you must file suit within a year. When you file a bond claim, some of these are recoverable and some of these are not on this list. Attorney's fees in general are not recoverable unless there's specific language in the bond that allows it. There's some other minor exceptions, but the default is that claimants must pay their own attorney's fees. For labor and materials, yes, those are things that can be recouped in a bond claim. And for materials of note, it must only be reasonably believed that the materials were used on a project. You don't actually have to prove that they were used to make a claim for those. For interest, post-judgment interest, yes, you can collect that after you file a claim. Pre-judgment interest is up to the court. So the classic lawyer answer of it depends for interest. When you file a claim, the surety doesn't necessarily pay it right off the bat. There are a number of defenses that sureties have to not pay on a bond. First is those time limits that we discussed. You have to make sure that you follow those. So it can be very quickly or up to 5 years for the Little Miller Act, technically, because that's considered a written contract, and the statute of limitations in Virginia for breach of a written contract is 5 years. If you fail to comply with the bond terms, then you may not be able to have an enforceable claim. Another thing is that the principal must be in default. So you can't go after the bond funds if there's no actual default on the original contract. There are other general contract offenses, lack of notice, improper termination, some of the things we talked about earlier. And then material alteration is an important one because when a surety issues a bond, it's consenting to the risk of a contract being defaulted on. But if there are change orders or other changes to that contract without the surety's consent, then the surety may not be obligated to pay on the bond. So if there are any changes to a project, make sure on which there's a bond, make sure the surety is aware of that and approves it before moving forward. Finally, in Virginia, sureties can demand that a claimant must sue the principal before going after the bond funds under Virginia Code 49-25. So that's everything for mechanics, liens, and bonds that I have for right now. I do want to issue a couple just words to the wise, general advice. Always double check your contracts. If you have a standard template, look over it every few months. You never know if you're going to catch something or if something needs to be reconsidered. It's just good to keep an eye on those things. In that same vein, make sure all licensure is up to date before you start a big project. When using progress payments, always specifically identify the scope of work that you're requesting payment for. Putting in that extra time and effort up front will definitely help you in the long run in case any issues with payment arise. Finally, with you happen to sign a contract that waives mechanics liens rights, it happens, but it's not the end of the world. Always remember there are other causes of action, including breach of contract, where you can still go to court or at least use that as leverage to get paid. One other thing I wanted to add that I'm seeing more and more, and I'm sure everyone is noticing it's becoming more prevalent, is about AI. And whether, do you need an attorney? Do you need to pay attorney's fees, or can you just go on ChatGPT and see what that has to say? There's no doubt that AI is here. It's not going away, but you have to be really careful with it. If you have a legal question, talk to an attorney. AI is not an attorney. It's a tool. It's not a guide. It's something that can be useful. It might make you a little more efficient in some of your day-to-day tasks. But again, it is not an attorney and can sometimes do much more harm than good. So I would just take that into consideration as this technology advances. And with that, I'll turn it over to Jesse to see if we have any questions.
Well, first of all, thank you so much. It really was great. You packed a lot of really great information into that, so I do appreciate it. And I love your little tips about the AI there at the end. Couldn't be more true. Just be careful with using AI information. It is a tool. It is not the golden rule and standard. Okay, there are a couple of questions that have come through. So the first one, it says, regarding the 150-day rule, if the job is large and takes a long time to complete, would it be permissible to file several liens?
Permissible, yes, absolutely. And so that's part of the strategy that you have to consider there. Do you want to file multiple liens? Because that is something that, as a practical matter, can upset a project owner or a property owner, because now there are liens on their property. So yes, if you have a project that's going on for that long and you haven't been paid, you may have to file multiple liens, but you do want to be conscious that that can be seen as an aggressive move by some owners. So you have to weigh the pros and cons of doing that, but it is 100% permissible.
Okay, wonderful. Thank you. Another question that came through, it says, if there are multiple bonds on a project, should I send it separate bond claims, one bond claim to the subs bond and then one bond claim to the GC's bond, or should they both be listed on the same bond claim?
So that's going to, I hate to always defer to this, but it depends, and it really does depend on the facts for that kind of question. Specifically, it's going to depend on what the terms of those bonds are. Typically, you're going to want to go up the chain one at a time. So if you are a second tier sub, you'll probably have to, you may even be required to go after the next in line sub, either the principal or the bond itself. And then if you can't get paid through that, then you could go up to the next level. But it's really going to depend on the language that's in those bonds to see what your options are first, before making a decision there.
Okay. All right. Thank you. And then it says, if a private commercial job is bonded, can I do the claim of lien and the claim against the bond?
Yes, you can definitely do both. There's no reason you can't. I think especially if it's a private job, there's no requirement for a bond. So I mean, unless there could potentially be language in the bond that says if you have a mechanics lien, you're not entitled to funds, but I think that's not something that I've seen. I'm just speculating here. To protect your rights, I would recommend going with both of those routes.
Okay, perfect. And then I have one more question. It looks like it says, when I send my lien via certified mail, you just need to include the proof of mailing on the recorded lien, not the proof that it has been received, correct?
Correct, because if you serve it by certified mail, it doesn't matter if it's actually received. I believe the statute just says that your obligation is to send it by certified mail. So as long as you include that certification, you're fine. Even if, say, it were to bounce back and come back as
Right.
undeliverable or something like that, as long as you have sent it certified and included that in the lien recording, you've done everything you need to do.
Okay, perfect. I do think that that's all the questions that have come through. If anyone does think of another question that wasn't addressed, please feel free to reach out and we'll be sure to answer any questions for you. Can you go to the next slide for me, please, Ryan?
Yes.
All right, here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Please remember, every state has its own unique lien rules and laws, what documents are required, what those titles of the documents are, and what the deadlines are. So if you're working in a neighboring state, please go onto our website. You can check to see what that state is, what your role is, and what type of project, and we'll kind of give you an outline of what's expected and what you need to do to protect yourselves. So please make sure that you are checking that out. All right, and then if you don't mind, go to the next slide for me, please.
Mm-hmm.
All right, this is, if you guys can give us a quick moment of your time to give us a review on Google, I would really appreciate it. It takes about a minute of your time, but it helps other contractors and suppliers like yourselves hear about us, and we always appreciate any feedback you can provide. It always helps us better ourselves and the content that we're trying to put out on these webinars. And then the next slide, if you don't mind. All right, and with that, that is all we have for you guys today. Thank you so much to everybody who attended. We hope to see you guys at our next webinar. Thank you again, Ryan. You really are wonderful. I appreciate everything and all of your time. I hope everyone has a beautiful and sunny day. Thanks again, everyone. Thanks again, Ryan.